Good evening. That day we discussed about the syllabus of the BPSC 68th, and today we are starting polity class, right? Now, before I enter into the details, let me deal with two terms which your syllabus writes. One is political system, and the second is Panchayati Raj. There are only two terms used in the syllabus expressly. The point is that if you look at these two terms, they appear to be very simple and small syllabus, short syllabus. But if you explain this political system, you will find that the syllabus is quite huge. Why? We will pick up this point only first. You see these two words, there are one is politics and the second is system. Now, what is politics? In Hindi, we call it Raj Vyavastha, right? If I write Hindi term here, it is Raj Vyavastha. This word Raj deals with state. So, politics deals with state at least. So, one has to remember or one has to learn what exactly is the meaning of state, then how does a state function, what are the challenges before the state, what steps the state takes to meet those challenges. Everything has to be studied when you study a state. That is one. Second is that a state will always function through policies. And policy is nothing but a set of guidelines to achieve an objective. We say that a state will make policies and will implement them to achieve a particular goal, or rather we can say that to achieve the ultimate goal which has been set by the constitution or which has been set by the state itself. So policy making and policy implementation, both are included in this term politics. All such policies which the state makes will definitely be guided by certain rules and regulations, and those rules and regulations are derived from constitution, right? Therefore, when you look at the syllabus, it appears to be a very small, you can say, topic. But if you expand what you have to study, you have to study state, its various dimensions, the process of policy making, process of policy implementation, their challenges, steps, and all these are guided by constitution. So you have to identify those areas which are related to policy making and policy implementation, which are enshrined in the Constitution of India. And that makes the syllabus quite huge. That is the one thing. Second thing, when you look at this word system, what exactly is the meaning of the word system? System, any system, whether it is biological or social, whether we say social system, political system, or if we look at the human body, you may have number of systems like digestive system, blood vascular system. So everywhere the word system is included, it means it has a common thread. And that common thread is that any system contains two things. One is the structural component, the structural parts, and second is the functional part. Structure means institutions or structures or organs and functional part will include interactions among these. Structurally, a system may be quite different. All structures may be quite different in their nature, in their form, in their functioning, but they do interact among themselves and they achieve a particular goal. So a system comprises various institutions, structures or organs, and how do they interact, that also we study in a system. And it also has at least one goal to be achieved by these. Is it okay? Therefore, we say that if we study political system, what are those institutions related to politics? Now, related to politics means related to state, related to policy making and policy implementation. And how do they interact among themselves? That also we have to understand. And what exactly is the goal to be achieved? That also has to be studied. And that makes the syllabus quite huge and wide enough. Of course, the Commission has written 2 express words, but it is not confined to only the definition of political system or things. It includes so many things. And if we say that it includes the Constitution, then Constitution itself is a huge document, right? So that way, syllabus is quite big one. And the other part of the syllabus is a part of that is Panchayati Raj, local governance. One thing we have to understand here, that Constitution is studied by number of people, say for example, by law students, by political science students, by students of sociology, then public administration. What we have to do? We have to understand Constitution only in this perspective. We are neither studying Constitution as a student of law or sociology or political science or public administration. We are studying in general because our subject is general studies. So we are studying the constitutional provisions in general with reference to all these. Only those things we have to identify from this Constitution. That makes the syllabus again contracted. So it is a very unique kind of feature. The syllabus is very vast, but if you understand the type of questions and the nature of questions which they ask, the area of question from where they ask the questions, then the syllabus becomes shorter. And that makes it easier that way. Right? This is what your understanding of the syllabus should be. And then we have to start studying from here or here. One has to understand what is the meaning of state and then what is Constitution, the classification of Constitution. How many types of Constitution do we have in the world? In which category we can place India's Constitution? What type of Constitution we have? Then what are the goals set by the Constitution? Once you understand the goals, then we can switch over to the sources of Indian Constitution, the characteristic or salient features of the Constitution, all these. And then finally we will enter into the constitutional provisions. And then we can find out what are the things related to this. So first of all, we'll start with the meaning of state, right? You say it is a politico-administrative concept or institution. Politico-administrative means politics will make policies and it will also implement them. For implementation, you have administration. When you say politics, politics includes both. Okay? But implementation is done by the administrative machinery or administrative setup. That's why we join these two words, that it is a politico-administrative concept. Okay. Now, going back to the history, there is a watershed year 1648. We have a treaty called Treaty of Westphalia. Prior to this treaty, the western part of the world was in furious or ferocious war, which we call 80 years war or 30 years war. More prominently, 30 years war ended with this treaty. And definitely the states who were involved in this, they must have been fed up by fighting for 30 long years or 80 long years. And they decided to come to terms that let us create an organization and let us try not to indulge into war in future. Okay? So we say Treaty of Westphalia was a peace treaty. And it was a pair of treaties actually, not one single treaty. It was a pair of treaty which was signed for ensuring peace among the states. And they decided to formulate certain rules, regulations, which we call Westphalian principles of state. So a state before Westphalia and after Westphalia, there are two concepts. Before Westphalia, they were not guided by any rules, regulations. That was absolutely subjective, we can say. What the ruler used to think, he used to perform. The moment ruler thought that, let me encroach upon my territory and let me overpower or capture the next one. So next morning, he might have launched a war. So there was no rule and regulation governing the states prior to Treaty of Westphalia. Treaty of Westphalia created certain norms, which we call Westphalian principles, and then the concept of modern state originated. That is our first question in prelims. Which of the, from where or from when the concept of modern state originated? That we have to remember, Treaty of Westphalia, right? Now, this Westphalian principles first of all, suppose there was a state A and this was a state B. First of all, they decided that let us have a fixed territory and let us determine a territory for our own. So A also decided, B also decided that we will have our own territory. And that principle is called principle of territoriality. That is, definite territory of every state. This was the first thing. Second, there was a government in both the states. So this government and everybody decided that this government will exercise its authority to the extent of this territory, not beyond that. So to the extent of this territory, the government will have its own power and nobody will intervene or interfere into that. So states decided that none of us will interfere into the internal affairs of other state. This is the internal affair. So no interference means principle of sovereignty. That was the second principle. Every state will remain sovereign until the territory. So there was a definite territory and sovereignty. The third was that this state maintains its sovereignty up to this point and it will not violate this principle of territoriality to enter into somebody else's territory. So there should not be any violation of territory. There should not be any violation of this principle of territoriality. That itself became a principle. And that principle is called principle of inviolability. Are you able to get it? Inviolability. This is, first principle is that there should be a definite territory. Second is that the government will exercise its authority without any external interference to the extent of the territory. That is sovereignty. And none of the persons from here, none of the state authorities or agencies will cross over this boundary and will enter into the territory of another state. So they will not violate the principle of territoriality. And that no violation itself became a principle, and that principle is called principle of inviolability. There will be no violation of the principle of territoriality. So these are the three Westphalian principles on which modern state was founded. Is it okay? So there are two questions from here. We can imagine, it is not sure that you will get a question of, but we can imagine there are two questions. One, the origin of modern state, Treaty of Westphalia. And modern state is founded on which of the following principles? So there are three principles: territoriality, sovereignty, inviolability. So even today, if I say that India is a state, India was created as a state, modern state, on these principles. So today also all states believe in these three principles. And that is the foundation of the modern state in the world. And that was in 1648, mid of the 17th century, we could say. Right? Now, based on that, we come to a conclusion that every modern state has four essential ingredients. First, territory. Second, population. Third, government. And fourth, sovereignty. These are the four essential ingredients of a state. Okay? There is another concept related to that, that is nation. This also originated from the same treaty. Now, what does this mean? Let me write one equation. State plus feeling of oneness is equal to nation. So, nation is in our feelings. That's why nation doesn't have a physical form. So, constitutions will not use the term nation. Constitution is the set of guidelines. So, it will give guidelines only to something which is not abstract. So, nation is an abstract concept. But it is political, administrative, cultural, and psychological concept. State is politico-administrative. This feeling of oneness comes from cultural traits. And the feeling is in our mindset, it is in our psychology. So, nation, we say that it is a politico-administrative, cultural, and psychological concept, which is abstract, it doesn't have a physical form. So, constitutions will use the term nation only when there is a possibility of generation of a feeling of oneness. For example, if I quote one example of Article 49 of our Constitution. Yes, DPSP. Article 49 says that a state shall protect the monuments of historical and national importance. So suppose I visit or you visit to Red Fort. And nobody will say that Red Fort, since it is located on the geographical territory of Delhi, so people from Uttar Pradesh or Bihar or Tamil Nadu cannot visit it. Then I will say that no, it is a national monument. It belongs to the nation as such. It means I and you, even if we belong to other different states, we are bound by one concept, that is nation. So protection of national monuments will generate a sense of oneness. That's why the Constitution will use the term at that point of time or at that place. Similarly, in preamble, we have integrity of the nation, unity and integrity of the nation. At other places, it will use the term state for the purposes of governance. Right? So these are the two concepts which we say they are derived from the Treaty of Westphalia. Okay? Then we have the term constitution. Latin word is constituere. It is applicable because the state is a part of nation. It is applicable everywhere. If the cultural traits are damaged, suppose, if there are cross-cultural clashes, then the feeling of oneness is degraded. So nation is weak. It means population does not have unity. So a state is also weakened. So a state also has to protect the cultural traits in any case. Both are together. And all these features will be equally important for a state also, for nation also. If a state is weakened somehow or the other, the nation is weak. If nation is weakened, then the state is weak. Yes. So nation feeling of oneness will vary from generation to generation, from time to time. Like we say that the sense of nationalism was at its zenith when we had Indian national movement. Today we do not require that kind of movement, but that does not mean that we are not nationalist. Our generation is also nationalist. The young generation is also equally nationalist. Otherwise, India would have been disintegrated by now. But at that point of time, the show of nationalism was important against the Britishers. Now, there is no need to show my nationalism to my own country. Yes, whenever it is required, we show our feeling of oneness. Got the point? Constitution word is derived from this Latin word constituere, which means supreme law. So constitution of every nation or every country is its supreme law. Fine? Now we can define this term in two different ways. One, we can say on its structural side or structural aspect, and the other is functional aspect. Again, two types. As a document, as source of power, and here balancer of power. So there could be three ways to define constitution. Okay. Now, as a document, constitution will include the nature of the state, the form of the state. It will give guidelines Okay, and it will highlight the goals and objectives, how to achieve them. Everything will be written. That is a document. Most importantly, we can say it provides for nature and form. You can note down nature and form of the state and the working guidelines. So we can define the Constitution that it is a set of guidelines to achieve a particular goal set by it, and it also deals with the nature and form of the state. Like when we say that India is sovereign, socialist, secular, democratic republic, so it gives the idea that India is a republic in form. It has a republican form of government. Whenever a person will read the Constitution, he will understand India that the head of the Indian state must be elected if it is a republic. It is not like British monarchy. It is not like, India is not like Britain, because there is no monarchy in India. And our head of the state is elected. Why? Because we call it republic. When we say US is a republic, it means president must be elected. Okay? So the document will provide the nature and form of the state, as well as it will provide the working guidelines. That is one written document. When you say Constitution as a source of power, it provides the powers and functions of all state agencies and authorities. For example, what president has to do, what the council of ministers has to do, what governors have to do, everything is written. So they derive their powers and functions from the Constitution itself. That's why we say that Constitution is a document which provides all these things. At the same time, it also serves as a source of power for all state agencies and authorities. Is it okay? Most importantly, this definition we should understand. What happens? Try to understand this. In a particular state, there are two things: the government and the people. Right? Government has the authority to do something, powers and authority. Powers and authority. What people have? What is our power? Our rights? Fine. Now when you want this system to run smoothly, neither of the two should either over-exercise their powers or misuse it. So both of them must be within limits to prevent the arbitrary exercise of powers. Right? In order to ensure that the system runs smoothly and there is no clash between a state and the citizen. It means the state's authority and people's rights, especially liberty, must be balanced. And for that balancing, what Constitution does, it sets the limits for the exercise, both for the authority also and for liberty also. Okay? For example, Article 14 of our Constitution, it writes that the state shall not deny to every person equality before law and equal protection of laws. The article says that a state shall not deny. There is a limit on the state. State can do whatever it wants, but it shall not deny this. So there is a limit. Similarly, Article 19(1)(a), freedom of expression, speech and expression. It does not mean that I will speak such things that will damage the integrity of the nation. If I speak like that, then my speech will be restricted. So there is a limit for the exercise of our rights also, and there is a limit for the exercise of the authority of the state also. And by setting the limits for both of these, the Constitution strikes a balance between the two. That's why we say that Constitution is a balancer of power, and that power balance is balancing the authority of the state and the liberty of the citizens. This sentence we can write in our definition. Here we can write. In our one definition, we can write a sentence. The Constitution strikes a balance between the authority of the state and liberty of the citizens. Liberty of the citizens by setting the limits. On the exercise of their powers. To prevent any arbitrary move. Okay? If suppose there is no balance, then what will happen? If a state oversteps, it is a kind of dictatorship. If citizens overstep, it is kind of anarchy. So, by balancing authority and liberty, the Constitution prevents dictatorial tendencies as well as anarchical tendencies. And that is its significance. That sentence also you can write. That by striking this balance, the Constitution prevents emergence of dictatorial as well as anarchical tendencies by limiting the authority and liberty of the state and citizens respectively. Got the point? So that is the definition of Constitution. Now, how many types of constitutions do we have? Classification of constitution. First is on the basis of ideology. On which idea the Constitution carries, which idea, or Constitution is based on which idea? That is what. First is liberal. Founded on liberalism, and hence lays emphasis on protection of liberty of the citizens. Got it? Second is socialist. Founded on socialism. What is socialism? Socialism has two components. Just try to understand this. One is related to ownership and the other is related to distribution. Means who owns the resource and who distributes them. If it is private ownership, it is capitalist. If it is community ownership, it is socialist. Ownership is with the community, and community itself or the estate which has been made by the community, the estate will distribute the resources equitably. Distribution of resources equitably. Equitably means according to requirements. Okay? So a constitution may be socialist and it believes in those 2 points: community ownership and equitable distribution of resources. That is the most important. Of the two, socialist constitutions primarily believe in this: distribution of resources. Primarily. Both are important. Ownership is also important. But any socialist constitution will primarily focus this: distribution of resources in equitable manner as per the requirements of the people. On the other hand, the third type of constitution is communist, which believes in primarily community ownership of resources. Like what we have in China. Chinese constitution is communist. So all communist constitutions will believe primarily in the community ownership. All socialist constitutions will believe primarily in distribution of resources. And all liberal constitutions will believe in protection of liberty of every individual. Okay? And the fourth, on the basis of ideology, is democratic. The constitution which lays emphasis on two things: equality and justice. Okay? Any confusion? If I ask you to place Indian Constitution in these categories, then we are democratic definitely. Our Constitution has democratic features or democratic ideology. Since we are democratic, so believe in liberty of the citizens also. So we are liberal also. Okay? Article 39B says community ownership of material resources. So we have certain communist features also. And 39C says that a state shall prevent concentration of wealth and means of production. It means the state will not allow concentration of wealth. It will allow the distribution. So it has a socialist feature also. So our constitution is unique in the sense that it carries all these ideologies. And all these ideologies, despite the fact that some of them are antagonistic, like these two. This believes in individual freedom. This believes in community. So they are antagonistic. But still our constitution has a unique feature that it has balanced all these parallel ideologies without any clash. That is the uniqueness. Second is, on the basis of form. There are four: written and unwritten, codified and uncodified. Written constitutions are documents providing working guidelines, nature and form of the state, etc. This is what a written constitution has as a document. Unwritten constitutions like Britain, like Israel, they do not have written constitutions. But unwritten constitutions always derive strength from written sources. So we say that sources of all unwritten constitutions must be written. Otherwise, it will be arbitrary. The lawmaker will work according to their own wish. That is not possible. So they derive the power and strength from the written sources. For example, in Britain we have Magna Carta. Have you heard about this? 1215. First document related to human rights. Then Petition of Rights, 1628. Then Bill of Rights, 1689. These three are the three pillars of British constitutional system. And all the constitutional functionaries or all state agencies and authorities, they work without a written constitution, but they have to follow these. They cannot go against them. The parliament also has to follow this. And these are the prime sources. Similarly, if you look at Israel, the primary law is called Hariri Rules. This is the source of Israeli constitutional system. And this is the kind of document which serves as the primary source of Israeli system. So we say that unwritten constitutions always have written sources. Fine? Codified word comes, or it includes a word called code. In Hindi we call it संहिता. like सुना है ना हमने IPC, इंडियन पेनल कोड, भारतीय दंड संहिता जैसे का, या कोड ऑफ क्रिमिनल प्रोसीजर CRPC, कोड ऑफ सिविल प्रोसीजर CPC. So what exactly is the meaning of code? Code is a law, right? What kind of law? That law will include all provisions of a particular thing at one place. Means if the court has to punish someone, it has to look at IPC. If a criminal procedure has to be initiated, how the trial will be conducted, who will file FIR, everything related to procedure is written in, everything in civil procedure is written in CPC. So all provisions of a particular subject is confined to one single document, then that document is called code. So if the constitution is codified, it means all provisions of the constitution are written in one single document. That is a kind of code. For example, if India's constitution, if you see, we say that Indian constitution is written and codified. Both. There may be a constitution which is written but not codified. There may be more than one document. For example, we have a very good example, Australia. Its constitution is written but not codified. It means there are more than one document. So codified constitution, you can write one sentence. Codified constitution means all constitutional provisions are included in one single document. For example, India, US, it is codified, written as well as codified. So most of the constitutions are written and codified. There is one exception, and that exception is Australia. We have two documents. You can say written but uncodified. We have one document called Constitution of Australia 1901, and the second document is Australia Act 1986. So there are two documents. That's why we say they are uncodified. Okay? This is another way of classifying the constitution on the basis of form. Third is on the basis of political structure. That may be unitary, federal. Okay, this we have to discuss in details also. Just now I will give you a reference. Unitary means central government. It creates local bodies and gives them powers, and then they will regulate citizens. This is unitary system. Now these powers which are given to the local bodies, that may also be withdrawn if needed. Some powers may be withdrawn, all powers may be withdrawn by the central government. So, central government is the most powerful authority and it directly controls the citizens. That is unitary. This is found in Britain, Japan, France, etc. Okay, generally what we find that those states which are geographically smaller, they have unitary system. Why? Because this is center. The radius is small. So geographical territory is small, so it is easy for the central government to govern. Population is less. But there is an exception here also, that a country which is geographically very vast but it is union, that is China. Because China is authoritarian state. So it has created provinces, no doubt. But provinces are as good as local bodies. So China is an exception in unitary system from the viewpoint of the extent of the territory. Generally, smaller territorial countries, they have unitary system, and the three are the best examples. Right? So, and powers are given to local bodies, they may be withdrawn if needed. When you look at federation, we have a center and we have states, more than one. Fine. So there are two-tier governance. Two-tier governance. How this design will work? Either the state will make a center. State will join hands, sign an agreement, form the center like what we see in US. Or the center may create states like in India. Okay? Both of them are federations. This we'll discuss in details when we'll talk about political design or political structure. So we say that on the basis of political structure, the constitutions either may be unitary or it may be federal. And lastly, on the basis of source or sources, one is granted constitution, second is enacted, third is evolved. There are three types. Granted constitution means the sovereign body has written a constitution, has framed a constitution and handed over to the people. He has granted. For example, if you look at absolute monarchies, kings, they used to set the rules and used to superimpose those rules on the people. So either absolute monarchies or dictatorships. Earlier it was very much visible in the world. Now absolute monarchies they do not exist as such. Yes, at the time, long back. Dictatorship is also almost over except one country that we have, North Korea, right now, at present. So what North Korean ruler will decide, the people have to follow. So granted constitutions means, in general, we can write the definition that sovereign authority frames it and grants it to the people. Indian constitution is also granted, but who has granted? People are sovereign here. So our constitution begins with we the people, right? It means people have made the constitution and people have given it to ourselves. It is written in the preamble that we adopt, enact and give it to ourselves. So we have made the constitution and we have given it to us. So our constitution is also granted, but the granting authority is neither a dictator nor an absolute monarch. It is basically the people. But there is a feature of this constitution also in our country, right? Second is enacted. It means a constitution passed by a legislative body. For example, our constituent assembly had passed the constitution, and we have written in the preamble that we adopt and enact. So we have given the legal status to the constitution. Enactment is the granting legal status to the constitution. Passed by a legislative body, so it automatically gets that legal status. That is enacted constitution. Evolved means over the period, the concepts have evolved. I will give you a very good example here. Our present constitution says equality of what? Of status and of opportunity, right? This concept of equality comes out from Article 14, and we say we have adopted or we got inspired from British constitutional system to give the content to this article. It means equality of status and opportunity is primarily inspired from British system. Fine? And that British system, actually it came after 1858. India became a colony of Britain after Queen's Proclamation, 1858. Then we may say that post 1858, the British system was truly working here. And if I say that we got inspired for equality from Britain, then that equality comes after this. But it is not true. The concept of equality was already embedded in our socio-cultural system since ancient time. Right? There is a case law here. We'll discuss that case law in details also. Just for your reference, there is a case law, Arumugam versus Rajgopal, 1974, in which the court held that equality is not a new concept to India, and it did exist in our ancient socio-cultural system. Justifying this statement, the court quoted two documents. One was the Rig Veda, Mandala 5. Mandal is the segment of the Rig Veda. And second was the Atharva Veda. It quoted a verse from Atharva Veda. It writes that all of us are brothers in the matters of food and water. That Atharva Veda writes. It means equality and fraternity were the two concepts existing at that time also. Definitely it was confined to food and water only. Now we have a status and of opportunity. So we say that our equality has evolved from being confined to food and water to become as wide as status and of opportunity. And that evolution took place from ancient to the modern period. So our equality is not sourced only from Britain. It was there. It was embedded in our culture. What we did from British system was how to present that concept in a legal language. That we got inspired from British system, not the concept. The concept was there already. But how to write that concept in the law, which language should be used, for that purpose we had seen different constitutions of the world. We did not copy it. We got inspired how to write the same thing in a jurisprudential language or in a legal language, that's all. It means our constitution is also evolved, and number of concepts and philosophies have become matured through the ages. And the framers had incorporated all those features and concepts, taking inspiration from various constitutions, writing it down in a legal language. But the system included those concepts and philosophies much earlier, right? So that way we can say a constitution, you can write here, the philosophies and concepts grow and get matured. The philosophies and concepts grow and get matured through the ages. through the ages. Okay? It means our constitution is granted by the people, it is enacted by Constituent Assembly, and it is evolved also. Generally what we say, that either constitution is either enacted or framed, or it is evolved. It is either or. It is either framed or evolved. Our constitution is very stable because it is evolved first, then enacted, and then granted. Got the point? There is a unique feature. First it is evolved. So we could see easily the concepts evolving and getting maturity. Then we incorporated all of them in a document, codified it, written and codified it, then passed it by the legislative body, and finally we granted it to the people. So it is evolved, then enacted, then granted. That is one of the most unique features of any constitution in the world. That's why we say that Indian Constitution is one of the finest documents, legal documents, the world has ever written. In terms of its concepts, in terms of philosophies, in terms of language, it is probably the best, if not the best, at least one of the finest, we can say. This is one of the justifications. Yes, all diversities, everything. And it is not simply that we have read 100 constitutions of the world. No, we had read Rig Vedic documents also. And we could derive something from ancient period also, and we could see that how the things went on, how the things grew and became matured over the period, and then finally we included them. That was the uniqueness. Okay, so all these are the types of constitutions. That's enough. There are so many classifications, but these are more than enough. So one we have on the basis of ideology: liberal, socialist, communist, democratic. Then we have on the basis of form: written, unwritten, codified, uncodified. Then we have either unitary or federal, and granted, enacted, or evolved. And interestingly, Indian Constitution includes all features. Fine. The definition and classification of this Constitution is like that. There is one term called constitutionalism. Now, ism is what? Ism is an idea. Idea. Socialism, liberalism, constitutionalism, conservatism, realism. Wherever you find ISM, it's an idea. Okay, so constitutionalism is an idea of what? Of preventing the state from being arbitrary. Very simple definition is this. Constitutionalism is an idea of preventing the state from being arbitrary in the exercise of its powers and authority. Okay? It means what? How to prevent? Setting the limit. The state shall not deny, the state shall not discriminate, the state shall not do this. There is a limit set by the Constitution. So setting the limits is the idea of constitutionalism. To prevent the state from being arbitrary in the exercise. That's why a country, a state which is guided by this idea is also called limited government or limited state. Means limits have been set. Limits have been set for the exercise of the powers. Fine? How to set the limits? We have one concept I am discussing here. It's a big concept in political science that we don't have to study. one recent thing is Louis Henkin in year 2000 has given certain features of constitutionalism. BPSC has asked one question in mains. What is the difference between constitutionalism and constitutionality? They have already asked this question. So constitutionalism is the limited government setting the limit for the exercise of the power, and constitutionality is the examining the validity of an action according to the constitution. For example, very recent example, 103rd constitutional amendment has been validated by the Supreme Court 2 days before. Must have read. So it means the constitutionality of the Amendment Act was examined by the Supreme Court and it found that it was not unconstitutional. So it has been validated. That is constitutionality. So examining the constitutional validity of some action or law is constitutionality, and limiting the state limiting the state for the exercise of its powers is constitutionalism. That was a very conceptual question there. So if they have asked in mains, they could ask in prelims also. Which of the following statements truly describes constitutionality? They can make a prelims MCQ also. Okay. So features of constitutionalism, first is governance according to Constitution. Every action of government must be what Constitution says. Second is separation of powers between legislature, executive, judiciary. Nobody should interfere. Yes. Third is popular sovereignty, means sovereignty with the people. People should be sovereign. Fine. Fourth is independence of judiciary. Judiciary must be independent to ensure the delivery of justice. Then limited government. Its powers and authority must have a limit. Second, control over police power. Seventh is civilian control over military powers. Okay? I'll tell you the example. And eighth is limiting the power to amend the Constitution. Some of these are the features. Okay? If you look at this, two articles I am quoting. Article 53, Clause 1 and Clause 2. 53, Clause 1 says that all executive powers of the Union shall be vested in the President, who shall exercise them according to the Constitution, either on his own or through his subordinates, for which the Council of Ministers gives advice. Right? That is 53.1. 53.2 says that without prejudice to the foregoing provisions, the supreme command of armed forces shall be vested in the President, which shall be regulated by law. It means President's military powers in 53(2) cannot override his executive powers. It is already written that without prejudice to the foregoing provisions. This provision cannot override this. So this executive power is given precedence. That is civilian control over military power. And this military power shall be regulated by law. It is written. Who will make the law? Parliament. So Parliament can make a law and restrict the military power of the President. So it is under the control of the civilian powers. If it was not the situation, then President would have been the military ruler of India, which is not possible. That is what we say, civilian control of the military powers. This is one. Control over police power means there is a doctrine of police power. Means what? That suppose a state wants to restrict our rights. The first thing is on which ground? Right? There should be a justified ground. Now grounds are written, 8 grounds are written in our constitution. Article 19(2) to 19(6). 8 grounds are there. Like security of state, defamation, morality, contempt of court, okay, sovereignty and integrity of India. There are altogether 8 grounds. In India, a state cannot restrict our rights on the ground other than these 8. But for example, in US, the state may find a new ground to restrict certain rights, maybe on very specific occasion, maybe in exceptional cases. But a state has the power to do that, to find a new ground to restrict our rights. That is not possible in India, even in exceptional cases. So our police power is completely under control of the Constitution. That's why we say that all features, this is there in India. Separation of power is also there. Popular sovereignty is also there. Judiciary is independent. Limited government, this is also there. 53(1), 53(2). This is doctrine of basic structure, you must have heard. That has limited the power to amend. So according to Hennequin, all these 8 features are present in our constitution. So we can say that Indian system of governance practices, in true sense, it practices the idea of constitutionalism. Okay? No confusions, hope? No confusions? Fine. Now let me come to the structure of the Constitution of India. Original and present. We had parts 22, articles 395 and schedules 8. Here we have parts 25, articles altogether 448, schedules 12 and amendments 105 till August 2021. Right? These are the changes. Now, what is the schedule? Schedule is the extension of the article. When you say Article 1, It writes, India, that is Bharat, shall be a union of states. Okay. How many states? Earlier it was 14, then it became 29, again today it is 28. And there are certain UTs, union territories. So the names of the states are written in the schedule. When Schedule 1 writes the names of the state, we can say that Schedule 1 is the extension of Article 1. All schedules are the extensions of certain articles. Okay? This is your area of question. Most important in prelims. What do they contain? We can write Schedule 1, 2, 3, and you can write the major heads, what they write or what they include. Schedule 1 includes names of the states and union territories. You can mention here. They will straight away ask that oaths and affirmation of justices are given in which of the following schedules. Straightforward question they will ask. From this structure, this is the area of your question. They won't ask how many parts or how many articles are there. They will ask questions from amendments and from the schedules. So Schedule 1, names of states and UTs. Schedule 2 is provisions in relation to, write down, provisions in relation to allowances, privileges, and emoluments of President, Governor, and ministers. Okay. Third is oath and affirmation. Except President and Vice President. Oath and affirmation. Fourth schedule is number of seats from Rajya Sabha. Fine. Fifth schedule is administration of scheduled areas other than administration of scheduled areas in states other than Assam, Meghalaya, Tripura, and Mizoram. Administration of scheduled areas in states other than Assam, Meghalaya, Tripura, and Mizoram. And Schedule 6 is administration in these 4 states. Administration in Assam, Meghalaya, Tripura, and Mizoram. Okay. 7th is division of law-making powers. On subjects in union list, state list, concurrent list. This also you must have heard. Schedule 8 is languages. These were in the original constitution, 8 schedules. 9th schedule was inserted by First Amendment Act 1951, and it includes land reform laws. Okay. 10th schedule inserted by 52nd Amendment Act 1985, and includes provisions in relation to disqualification of a member on the ground of defection. Right? 11th schedule inserted by 73rd Amendment Act 1992 and includes 29 subjects for Panchayati Raj institutions. And Schedule 12 inserted by 74th Amendment 1992 and includes 18 subjects for municipalities. These are the 12 schedules, we can say, and the headings will give you the questions. Right? That's enough for basic introduction. What is a state? What is nation? Treaty of Westphalia, Westphalian principles, then the concept of constitution, classification, and the structural part of Indian constitution. Any confusions in this? Schedule 3 is not one single article, extension of different articles. Like when you have president or governor or justices. No. They will ask, see, out of 12 schedules, your most important is 5th, 6th, 7th, 8th, right? Then 11, 12. 7 to, 5 to 12. They are important. Like defection is very much in news recently, anti-defection law. So they may ask, anti-defection law is 52nd Amendment. 52nd Amendment Act was called anti-defection law. Or Schedule 10, yes, they can ask Schedule 10. So that all depends on which of these provisions is in news. That way they can frame the question. If suppose language is in news, then they may ask Schedule 8. If land reforms laws are made, they may ask 9th. And there could be two different types of questions. One is what it contains, schedule. Or the second, by which Amendment Act it was inserted. That may also be asked. So amendments like first, then 52nd, 73rd, 74th are important. That's enough for the basic terminology. Okay. Now we have to discuss, first there are three things to be discussed as a basic concept. One is the sources of the Constitution. And a very good question they may ask, that which of the following is to be considered the most important source of Indian Constitution? Right? Options may be Government of India Act 1935, American Bill of Rights or American Constitution, British system, right? Or any other. Now, which of these sources is the most important? Suppose I say it is Britain because we have taken parliamentary system. Then somebody may object that our system is parliamentary, fine. Our system is democratic. That's why we adopted parliamentary system. And in any democracy, rights of individuals are most important. Rights we have taken from US. So why not US is more important than Britain? I may have an objection. Fine. Another person may object that more than 200 articles we have taken from Government of India Act. So that should be the most important source. our purpose to study the sources is not to simply to remember the names from where what. We also have to understand the importance of the source, at least 4 or 5. Fundamental rights, parliamentary system, directives. Okay, so that also we have to discuss. That is one. Second is the features of Indian Constitution. Now, when we say the word features, how many types of features do we know? One is category, means features. One is salient. Another may be characteristic. Another may be exclusive. What is the difference? Salient features are which you see commonly. Everybody can see it from outside. Most prominent. Like Constitution is the lengthiest document. It is rigid and flexible. There everybody can notice it. That is salient feature. Characteristic features means things which have built its character. Now what is the meaning of the word character? Character of any institution, character of a person. So character is nothing but, very simply, character is nothing but aggregate of values. Right? If I say that what are the characteristic features of Indian Constitution, so we have to identify the values contained in the Constitution. For example, equality, justice, fraternity. These are the values. Separation of powers, which will lead to independence of judiciary. So those values have to be identified as features. They are called characteristic. Okay. And third is exclusive features, means which are not found anywhere else. No, decentralization is found in other parts also. For example, we have a combination of separation of power and fusion of power. Both. Yes. Unified judiciary, decentralized judiciary. So decentralization and centralization, both are opposite, but we have blended it. That blending of two opposite concepts is not found anywhere else. Single constituent authority. Only the parliament has the power to amend the constitution. Right? Single constitution in a diverse country. It is very difficult to apply one single law across India having so much of diversity. But it has been highly successful. Yes, and it has virtually contributed to unite India and keep India integrated. Constitution has a major contribution. So there are certain exclusive features. Why I said this? Because they will not classify these features in prelims exam, obviously. But if you understand these features, then you can easily solve the questions. And if suppose they ask in mains that what are the characteristic features of Indian Constitution, and if you know the difference between salient and characteristics, your question will be different from the crowd answer. Otherwise, everybody will write rigid constitution and flexible and longest document and this and that. Yes, but if one sentence you write that characteristic features mean this, and how are they different from salient and exclusive features? In one paragraph you mention this, and then you write the features, you'll get extraordinary marks. That will be the advantage. That's the reason why I discussed this. But that we'll discuss later on. First of all, we'll talk about preamble to the Constitution of India. Because unless we understand the preamble, we cannot understand other features and why did we take something from some country. So sources and features we'll discuss after finishing the preamble. Right? So we'll talk about that. Generally, what we say that preamble is an introduction. Okay? And we say it is as good as preface of a book. But preamble is not the preface. Preamble to a constitution is not a preface of the book. Why? Preface of a book will contain what? Why this book is being written by the author? He will write that. Who are the readers, possible readers of that book? From where it has taken the sources? He may express his gratitude to someone that without him it was not possible for me to write. It will write what are the exclusive features in certain chapters. Chapter 1 contains this, 10 contains this, right? These are the contents of the preface. Across the world, whether a book is published in US or in India, it will follow the same thing. Similarly, if we call or use this term preamble to all constitutions, it also must contain certain essential features. Otherwise, we could have written this preface. But it is not the word preface anywhere in the world. Right? Every act and every constitution must have a preamble as a rule. As a rule of jurisprudence. Jurisprudence is the legal theories. As per the legal theories, every act and every constitution must have a preamble. When you see any act, let's say IPC, section 1 of every act world over will write same thing. Short title of the act. First section. When you open IPC, first section will say, this act shall be known as Indian Penal Code. Okay? And then it will follow whatever it wants. It will tell you the introduction of the act, and that gives the objective. The moment it writes that this act shall be known as Indian Penal Code, it means it is a code for penalty. So all provisions related to penalty are confined or codified here. So the next section, section 2 to 512, all will deal with punishments. This is highlighted by section 1, which serves as the preamble to the act. Got it? Similarly, every constitution must have a preamble. So preamble to every constitution must contain certain essential features. Now what are those features? We say essential ingredients. One is philosophy. Philosophy of the state. But philosophy is an idea. An idea is abstract. So philosophy incorporated in the preamble is not expressly written. It is in abstract form. You have to understand the language, interpret it, and dig it out, that this is the philosophy. So it remains in abstract form. Right? If you want to achieve the goal, which remains abstract, you cannot achieve it. Your goal must be visible. No. Without the visibility, how can I achieve it? I want to go to, say, Connaught Place in Delhi. If Connaught Place is not visible, where will I reach? So abstract philosophies cannot be the goals. There has to be certain goals or objectives which are expressly mentioned. Right? But those objectives or goals must be derived out of this. If you achieve those goals, you will come to that philosophy. So objectives and goals derived from the philosophy, that is the second essential ingredient in the preamble. Fine? Expressly written in that. And the third thing is how to achieve these objectives. So the third thing will be the guiding principles by which you will achieve these goals and objectives. These three have to be there in preamble to every constitution. In addition, they may write whatever they want according to their own requirements. But these three have to be present in any case. That's why we call this part of the constitution which carries these three things is called preamble everywhere. That's the common thread to achieve these goals. What the state has to do. This is objective. What you should do. This will tell how will you do that. Yes. Say for example, India wants to ensure democracy. Democracy is one of the objectives. What the state should do and how it should be achieved. Then the preamble writes that a state must provide social, economic, political justice, equality of status. A state gets the guideline that I have to ensure equality of status by this thing. I have to protect the liberty of the citizens. Liberty of what? Speech, expression, worship, faith, all that. These are guiding principles. Okay, so preamble will contain these three things. Now, if you look at India's preamble, the philosophy is welfareism. India is a welfare state. It wants welfare of everybody, all individuals. Okay? But welfareism, all India shall be a welfare state, that is mentioned nowhere in the constitution. Right? So it is in abstract form. Our philosophy contained or enshrined in the preamble is welfareism. Now what we have written, that certain objectives and goals must be derived out of this. Okay? Now what we say, India is, understand this, sovereign, socialist, secular, democratic republic. These are the words. Now these two words we added in 1976. Suppose if I add this, write in English sentence, India is a sovereign, socialist, secular, democratic republic. Suppose these words are not there. Then India is a republic. Grammatically it is correct. Subject, verb, object. So sentence is correct that India is a republic. What kind of republic? Then sovereign, socialist, secular. So these could be called adjectives. Am I right? Primarily India is a republic. Fine? When you say sovereign republic, it means people have the right to decide. Then democratic, your freedom, liberty is most important. If you are democratic in true sense, can we say that we are sovereign also? If I am truly democratic, then my liberty is well protected, then my sovereignty will also be protected, nobody will intervene. So if I write India is a democracy, it will include sovereignty also, some component of sovereignty. Fine? Can it include secular fabric also? If I am democratic, I will be liberal. So I will be respecting all religions liberally. There will be tolerance. So secular features are also included in this. Sovereign features are also included in this. Socialism may not be included. So even if I don't write sovereign and secular, and if I write democratic, the purpose is served. Some part, but essentially most of them are there. So democracy is more important word than sovereignty and secular. A sovereign nation may not be always democratic. Like any monarchy. North Korea is also sovereign, but it is not democratic. But a democratic nation has to be sovereign. Got the point? So democracy is more important word than these two. It's wider concept. So one objective of India is to ensure democratic features. And this socialist word is different from democracy. So another goal is socialism. Our philosophy is welfareism, and the objectives derived out of this are twofold: democracy and socialism. So our objective, we can say, it is a different form of socialism called democratic socialism. Got the meaning? Concept you got, I think. How we derive that democracy and socialism are two most important terms. That's why they were not written. They were not written. We inserted it in 1976. Our purpose was served. They were written inside the Constitution. It was not expressly mentioned in the preamble. So our goals are this, objectives. How to achieve this? The guiding principles are justice, liberty, equality, and fraternity. These are the guiding principles. That is what the preamble of Indian Constitution says. Okay? Now, what do you mean by welfareism? Doing welfare of someone means what? If suppose I draw this, that this is the mainstream of resources. Okay? Group A is included. Group B and C are out. Say for example, OBC, SC, ST. They are not having access to resources. They are not getting proper opportunity or equal opportunity. So they are excluded. What you have to do? The state has to provide them facilities and include them here for welfare. This is welfare. It means ensuring the inclusion of a family or a group into the mainstream of development so that he is able to access the resources on sustainable basis, not for once. He should access the resources sustainably. That is what we call welfare. These resources may be social, political, economic, all environmental, natural, all resources. For doing welfare, you have to provide access to all such groups, including this, all such groups equal access to the resources. I should not have a feeling that I belong to SC category, so education is not my domain. It is the domain of OBC or general candidate. I should not have a feeling like this. I should also get equal opportunity like any other group. Then the state will say that we have done welfare to SC. Got the point? So welfareism cannot be confined to one particular area. It will have different aspects like political, economic, then social, cultural. At least 4. Politically what? Every individual's democratic rights must be protected. So this is democracy. Democracy is based on which idea? Liberalism. Right? And it means what? Protection of rights. What a state has to do? You have to protect the rights, and then you can say that I have done political welfare to a particular group, because by protecting the rights, we have protected democracy, and we believed in the idea of liberalism. Fine? Economic, it is based on the idea of socialism. Means what? Equitable distribution of resources according to the requirements. This we also call distributive justice. This concept is also known as distributive justice. So by equitably distributing the resources, we will protect the ideology of socialism. Then we will say that we have done economic welfare. Social welfare means no discrimination against anybody. And this is based on the idea called egalitarianism. Okay? For that, what you have to do? No prejudiced behavior against anyone. I should not have a behavior against anyone which is prejudiced. Then only I will be discriminating someone. Okay? And cultural is equal respect to all religions based on secularism, right? So the preamble tells what? In one sentence what we can write. That will help you writing answer in mains also, although we are discussing it for prelims, but we can write that India is politically democratic, economically socialist, socially egalitarian, and culturally secular state. That will be a powerful statement. India is politically democratic, economically socialist, socially egalitarian, and culturally secular state. Now, what does this mean? We can write in other words explaining it. It believes in protection of rights based on the idea of liberalism, equitably distribute the resources for protecting socialist tradition, does not practice prejudiced behavior to ensure equality of status, and gives due respect to all religions so that there are no religious clashes. So by reading preamble, we can understand the nature, form, goals, objectives, philosophy, everything of India. That's why we say it is heart and soul of the Constitution. And that is why the Supreme Court, whenever it interprets the Constitution, it has to keep preamble in front. Okay? This is what an outline of the preamble is. In next class, today is this enough. In next class, we will discuss the details of the preamble And all these words we'll discuss: sovereign, socialist, secular, democratic, republic, and then we'll go further to study. After this, it is easy for us. From where did we get this? From where did we get this concept? So it will be easier for us to understand the importance of the sources. Now, of this, which one is most important? Again, democracy. If you are democratic, you cannot discriminate. You cannot discriminate on the ground of religion, or without discrimination, you will always equitably distribute. The most important thing is democracy. How to justify? There is a concept called doctrine of waiver. The Supreme Court says that none of us in India can waive our rights. So we say right to life does not include right to die. Got my point? Right to freedom of expression does not include right to be quiet. If I am asked to be present before the court, the witness cannot say that I will not speak. I will exercise my right to be quiet. No. If by being you or remaining you quiet, if it hurts or violates the rights of others, you will be forced to speak. So court says that none of us will waive our rights. Why? Because it will hurt the sentiment of democracy. They can remain silent to the extent of infringing others' rights. That's all. We have a very good, interesting statement we can say. There are two statements. India is a democracy, so we have been given rights. This is one statement. Once again, India is a democracy, so we have been given rights. Right? It means democracy is more important than our rights. This statement tells that since India is a democracy, therefore we have been given rights. So primarily it is democracy. So democracy is more important in this statement. Another statement. We have been given rights, so India is a democracy. So our rights are more important than democracy in the second statement. Second statement is not true for us. First is true. That India is a democracy, so we have been given rights. So by waiving my rights will hurt the sentiment of democracy. And neither a single citizen nor the state is allowed to violate democratic norms. All such actions will be unconstitutional, or it will be an offense. So democracy is very strong in Indian system. Now, if suppose democracy is most important word, so the source from where we derived this concept, democracy, that should have been the most important. Got my point? And that democracy is parliamentary democracy. So we took it from Britain. So British source is most important. Then only comes the rights. So next important source may be US, but the primary important source is Britain, because we derived the concept of democracy from there. Is it okay? So if we understand preamble and its details, it is very easy to understand the importance of sources and features of constitution and all that. That we'll discuss tomorrow, right? Thank you. Sandeep.